Thanks for logging in. We have some very important updates we'd like to share. How we're going to do this is we're going to have AG provide some comments. Afterwards, we'll of course do questions. If you want to have questions, since we're all virtual, please enter them in the chat and we'll read them afterwards. So with no further ado, we will have Ohio Attorney General Dave Yost.
Good morning. Transparency is one of the most important values at our office, and it's nowhere more important than when the authority of the government exercised by police results in the use of deadly force and the loss of life of one of our citizens. Thankfully, these occasions are rare, and they're generally justified by a threat to that law officer or some other person. However, because it's so important to have trust between law enforcement and the communities they serve, I've made it a priority for my administration to talk as early as we possibly can and as completely as we possibly can about the investigations we conduct and where we're making decisions, what those decisions are and what they were based upon. While transparency is important, of course, there are competing legitimate moral and legal interests, values, like a fair trial, that also need to be weighed, and we are not able to be instantly transparent for several reasons. Number one is that the investigation takes time to complete, sometimes quite a bit of time, and until we actually have completed the investigation, we don't know what we don't know. And that's why it's an investigation. And it's only, you can look at several instances here in the last year where the initial hot take on the first day ended up looking very different a few days later when more information began to come out. It's critical to reserve judgment and for us to not talk about the investigation before it's appropriate to do that. Not only would it potentially create an incorrect, inaccurate, incomplete impression, but it would also denigrate the value of the final truth, because people very rarely will remember the last thing that they heard from the completed investigation without remembering in the context of what they heard to begin with. In addition, the potential for criminal charges demands that we preserve the integrity of the jury pool so that if an indictment is brought, the case may be fairly and impartially tried to that jury. In addition to that, there are legal constraints regarding the investigation, what's appropriate to talk about and what is not. There are practical considerations in terms of tainting the potential witness pool with other information. People begin to have a difficulty distinguishing between what they actually saw and heard and how it was interpreted or what they heard from other people. We don't want witnesses tainted by having heard extra sources of information. We want to know what they saw, what they heard. And finally, the grand jury process itself is mandated by the Ohio Constitution and is governed by statute and criminal rule that preserves secrecy. There's good and sufficient reasons for that secrecy. Perhaps they are attenuated in some ways when it comes to the public exercise of authority, but it's the system that we have. So with that background, I want to briefly bring up a slide on your screens and walk you through a pretty simple diagram of the process, because it's not always obvious how this actually works, and it can be pretty confusing what happens when. It starts, of course, with an incident where lethal force is used and then goes to a law enforcement investigation immediately. Now, this may or may not be the Bureau of Criminal Investigation in the Attorney General's office. It may be a local agency, a law enforcement agency. It may be an agency that is invited in by the agency that employs the officer involved. Right now, those things are completely up in the air. And while there has been a move toward independence in these investigations, it is not currently mandated by law. Well, let me be clear, it ought to be. And I've asked the General Assembly to require independence in the investigation of officer-involved critical incidents. I hope to see action on that yet this year. Once the investigation is completed, whether that's by the agency that employs the officer, an independent agency that was invited in, or the BCI or United States Department of Justice, it is sent to a prosecutor for review. It's important to know that while we sometimes have a prosecutorial role in the Attorney General's office, we don't have original jurisdiction on any criminal case involving an officer-involved critical incident. It always resides with the local prosecutor that's elected by the people. Similarly, we don't have any original jurisdiction to just go in and take over a crime scene or the scene of an incident. The things you see on TV where the FBI just shows up and takes over, that doesn't happen at the state level. We have no authority to intervene unless we are invited in, either by the law enforcement agency or by the prosecuting attorney. The prosecutor's review goes through the investigation, looks for the elements of a potential crime, looks for the reasonableness of the force that was used and whether it was appropriate under the law. And our office is frequently invited in to undertake that analysis and the potential prosecution. In a few moments, you're going to hear from Anthony Pearson, a senior assistant attorney general who heads up these projects for us and is an expert in the area. He's going to talk to you about one that occurred near Cleveland. But whether it's the local prosecutor or the attorney general, the next step is to present the case to a grand jury. Grand jury is secret. It is a group of citizens that review the evidence. And in this case, if my office is handling it, we're very careful to present all the evidence we can find and to be very thorough, not just to meet the probable cause standard, but to put everything in front of the jury to give them an opportunity to make a fair, informed, complete decision because of the stakes involved in this particular kind of case and the use by the government of lethal force. Grand jury has a couple of options. They can return something called a no bill. Now, a no bill is basically just a piece of paper that said, whatever happened, we don't find a probable cause to believe that a crime was committed. Now, that doesn't mean it was right. It doesn't mean that it was just, and it doesn't mean that it was morally good. It certainly does not mean that that death was not a tragedy. A death is always a tragedy. What it does go to is the question of whether the use of force was justified under our law in the United States. The alternative, of course, to a no bill is to an indictment. An indictment is just a charge saying that there's probable cause to believe that the crime occurred. And at that point, it goes to either a plea or a trial. If there's a trial and a guilty verdict, it can go to appeal. So here are the ways that a case is closed. A no bill from the grand jury, a plea of guilty by a defendant after an indictment, a acquittal or a conviction after a jury trial, or if there is an appeal, a final appealable order or final order, terminal appeal, that there's no further appeal possible. Any of those events, the case is closed, and at that point, it becomes public record. So when BCI investigates, the entire investigation is confidential, even after it's given to the prosecutor. Today, we're going to talk about a case where we did not do the investigation up in Cleveland. We did serve as special prosecutor. Anthony Pearson of my staff handled that case for the grand jury. So before that, before I bring Anthony up, I want to mention two other related things, again, in the interest of transparency. Two cases that have had some profile locally here in Columbus were sent yesterday to the Franklin County prosecuting attorney. These are cases where the Bureau of Criminal Investigation and Identification performed the investigation, has completed it, but we are not serving in the Attorney General's office as a special prosecutor. The county prosecutor has elected to review these cases and will make the decisions relevant to them. The first one is our case file from this year of number 584. This is the shooting at the Walnut Creek Bridge over 270, and case number 957, Micaiah Bryant. And both of those investigations are now complete and have been forwarded to the Franklin County Prosecuting Attorney's Office. I expect it to take some time, at least several weeks, and perhaps longer, for the attorneys there to review the voluminous material that we're sending them. And then they need to do their legal analysis and schedule time for grand jury. I urge you to give them time to make a fair, just, and complete decision that will not be instantaneous. So today we're here to talk about an event that occurred on November 13th of 2020. Arthur Keith lost his life in an interaction with an officer employed by the Cleveland Metropolitan Housing Authority. And to present that, the information about that investigation and the outcome of it, I have asked, as I said, Senior Attorney General Anthony Pearson, who presented the case to grand jury, to be here and outline those details. Mr. Pearson, there you are.
On November 13th, 2020, Arthur Keith died as a result of an officer use of force. This incident happened at the Cleveland Metropolitan Housing Authority, the King Kennedy complex near Halt North Walk and Bundy. CMHA police officers were dispatched there on a report of an individual with a gun. The person who called 911 indicated that he had seen that person there before on prior occasions shooting off a gun, and he was confident that that individual had a gun today, on that particular day. He also gave a description of the vehicle that this individual was in. Officers responded. It was about 4:40, between 4:30 and 4:40 in the evening on that November 13th, 2020 date. CMHA police officers arrived on the scene. It's my understanding they have jurisdiction over housing authority complexes, and as a result, they were dispatched. They arrive on the scene. 3 officers arrive on the scene to investigate this black Chrysler, for which this 911 caller identified as having the individual with the weapon. As officers approach that vehicle, they see someone moving inside. One of the officers opens the door to that vehicle and sees an individual who was later identified as Arthur Keith in the back of that minivan with a gun. The officer gives commands for Arthur to drop the gun and to get out of the vehicle. Mr. Keith gets out of the vehicle, turns toward the officer, and according to the officer, points the gun at him. At that point in time, the officer fired 4 shots. Mr. Keith was struck once. The bullet went from near the back and under his armpit, cut through a rib, his chest area, his heart, and a lung, and exited out his right chest. After he was struck, Mr. Keith attempted to run. He ran for a few steps and ultimately collapsed. Officers approached him, immediately saw that there was a 9mm handgun within arm's reach of Mr. Keith. That 9mm handgun was set aside. Mr. Keith was handcuffed for a brief period of time till they realized that he was non-responsive and had been hit. Then officers started to perform CPR on him. They called dispatch, immediately radioed for EMS. Officers attempted to life-saving techniques that were ultimately unsuccessful. Paramedics arrived and took Mr. Keith away. The gun was retrieved and analyzed. Mr. Keith's DNA was on that weapon. It was on the trigger, the slide, and the magazine. And as I stated, Mr. Keith did not survive that single gunshot wound to the chest. The investigation was completed by the Cleveland Police Department. They did canvas interviews. They interviewed multiple witnesses in the area. They interviewed the response by the Cleveland Police Department. The Cleveland Police Department has body cams, so their footage was reviewed. The Cleveland Metropolitan Housing Authority police officers do not have body cams. So the incident in of itself was not captured on video or any other recording mechanism. However, the aftermath of what happened was captured on video. A camera from the Housing Authority captured not the shooting, but Mr. Keith falling and officers approaching him at that point in time. The investigation, as I stated, included reviewing 911 calls, reviewing dispatch calls, radio runs, looking at where the car that Mr. Keith was in, the origin of that, the origin of the handgun that Mr. Keith possessed, and interviewing witnesses. As a result, this investigation was presented to the grand jury, and the grand jury ultimately felt that Officer Griffiths acted reasonably, and therefore there was no bill to that indictment, and the case was not indicted. None of the officers were indicted for any criminal conduct.
Thank you, Mr. Pearson. I mentioned that we do 2 parts of an officer-involved shooting. We do both parts very well through an impartial process, people that are career experts at this. In fact, at BCI, we have a supervisor of special agents named Mark Kohler. He's done over 200 officer-involved critical incidents in his time. And as I have worked with him over the last couple of years, became very impressed with the depth of his knowledge and the rigor of his methodology in investigating these cases. I asked him to consider writing a book, and along with Anthony, a number of other people in both BCI and here in the legal sections of the office, we have published this book, Best Practices for Investigating an Officer-Involved Critical Incident. It's literally a how-to manual on how to organize and execute an investigation. I'm very proud of our team for having put this together. It's available online for free and is, again, part of our priority to be transparent about what we do, how we do it, to be complete, and to communicate with the communities that we serve. So thank you for joining us today. I'll be happy to try to take any questions, and obviously Anthony will be here for any detailed matters on the Arthur Keith case.
The first question is from Lacey Crisp with 10TV.
Good morning, and thank you for having this press conference. I was wondering if you could tell us what the latest is with the investigation to the Casey Goodson, Jason Meade case, also the St. Anne's fatal officer-involved shooting.
Thank you. The Goodson case is being investigated by Columbus Police Department, not by us, and I don't have any update for you on that. I'm not involved with it. And to date, Carol Hamilton O'Brien is here. We've not been asked to take that as a special. So we have no involvement in that. The St. Anne's case is still under investigation, but nearing completion, and I hope within the next couple of weeks to be with you again to share what facts we're able to share on that.
Next question is from Scott Roll with News 5 in Cleveland.
Were eyewitnesses from the housing complex called to testify before the grand jury? And if not, why not?
I don't believe I'm at liberty to say what individuals testified to the grand jury, but they were interviewed, and multiple requests for civilian witnesses were subpoenaed to testify in front of the grand jury. I can't tell you who appeared or what they said, but I will tell you that multiple individuals, civilian witnesses, were subpoenaed to testify in front of the grand jury.
They were subpoenaed. Did they actually testify?
I'm not at liberty to say. But I can tell you my practice with respect to individuals who I have subpoenaed to testify at grand jury. If they do not appear, I do provide that statement that they've provided to law enforcement to the grand jury for the grand jury to evaluate, and that is in every case that I do. So information that they have provided to law enforcement, whether they appear or not, is presented to the grand jury.
Next question is from Dustin Insing with Onward News.
Hi, I was wondering how optimistic you are that legislation will be signed into law providing your office with jurisdiction over these cases, and why do you think that's so important?
Thank you. First of all, let me clarify something. I am not asking for all of these cases to go through BCI. Frankly, I think that would be very difficult because of capacity issues. What I'm asking is that they be independent. So whether they're conducted by another agency or BCI or on occasion the United States Department of Justice, the key is that the agency employing the officer that is involved should not be investigating its own. No more DIY investigations. Now, as far as how optimistic I am, I'll be candid with you. I've been working diligently, my staff's been working diligently with members of the legislature as well as stakeholders in the community and in law enforcement for a year to try to bring together a package for police licensing that would include this kind of a no DIY investigation provision. To date, while we remain hopeful, that bill has yet to be introduced after many, many, many drafts that we've gone through in this process. So I guess I'm not going to handicap that. It certainly would be possible for a no DIY provision to be a standalone bill and not included in the licensing. And if that's all we can get done at the moment, I hope we at least do that. But make no mistake about it, we need to do more.
Next question is from Farnoosh Amiri with the Associated Press. Can you hear us? Okay, we'll skip down. The next question is from ABC 6. They entered their question as, what is the latest on Michaela Bryant?
Thank you. The Ma'Khia Bryant case is completed for the investigation. It has been forwarded to the Franklin County Prosecuting Attorney's Office, which will handle the prosecution and therefore the analysis to presentation to grand jury and any charging decisions.
The next question is from Dan Perlman.
Hi, Attorney General. I see that in the Ma'Khia Bryant case, the BCI interviewed 15 civilian witnesses and 3 law enforcement officers. Can you say if one of those law enforcement officers was Officer Nicholas Reardon?
I cannot at this point identify the identity of the witnesses we have interviewed. We will identify those people as we're able, but the process needs to work. We are providing more information right now and volunteering that the investigation is completed and forwarded to the prosecuting attorney's office in an effort to reassure the community that we, in fact, are on top of this. We are diligent and complete. But we don't want to compromise the integrity of the work or the legal process by speaking about details that are not within our purview to discuss.
Next question is from Matthew Richmond with IdeaStream.
Sorry about that. I thought it'd just be read off. I'm wondering about the video recorder at CMHA offices at King Kennedy. According to CMHA, it remained in the administrative offices for 6 days before it was taken in as evidence. And I'm wondering if you have information on who accessed the recorder and whether the cameras that were closer to the shooting were just not working, if that footage was lost, what happened to that footage?
I don't have information as to who accessed any possible footage to present to you at this time. However, the footage that was captured was from one particular camera. I don't know the exact designation of it. If I had a map, I guess I could point it out on a map, or once the camera angle is seen, it could be identified, but I don't know off the top of my head which one it was. As to the other cameras that were not operable, we've had multiple offices look at retrieving video and they were unsuccessful in retrieving any video that may have been taken from there.
And the next question is from Andy Chow with Ohio Public Radio.
Hi, everyone. Just wondering, what's the standard for law officers' use of force that the grand jury is asked to consider when evaluating a case like Arthur Keyes?
Go ahead, Matt. Thank you. The grand jurors are instructed on the law regarding officer-involved shootings. And essentially, it boils down to whether the officer's conduct was reasonable under the circumstances in the light of a reasonable officer. It's about 3 pages of law that is read to the grand jurors multiple times throughout the grand jury process, depending on how long that process is. And it includes various case law that has been handed down by the Ohio Supreme Court and other courts that have binding jurisdiction in Ohio. Additionally, with respect to grand jurors, our practice is to also inform them that if they find the officers acted reasonable, then they will not be considering other charges. Those other charges are explained to them, such as murder in the instance that someone dies, murder as a result of committing a felonious assault if someone dies, or felonious assault. The grand jurors are talked about those particular crimes and potential charges. However, they also instructed that they must first find that an officer's conduct is not reasonable under the circumstances. Thank you.
The next question is from Paul Teasley with Hannah News.
Thank you. Can you hear me okay?
Yeah.
Great. To your question, I'm sorry, to the Attorney General, to your comment about independent investigations, how concerned are you, or what concerns do you have about how local politics and perhaps even national politics play into investigations to the extent that they are done locally, and prosecution of officer-involved fatal shootings?
Well, first of all, let me say unequivocally that politics, national or local, do play no role in the work that BCI does. They're insulated, they are professionals, and they do their work without regard to external factors. Their sole mission is to find the truth. Now, as an elected leader, let me say that I am very bothered by particularly elected leaders who ought to know better, who immediately rush to judgment, who call for particular actions, whether it be an arrest, an indictment. The process needs to work, the truth needs to be found, and each one of these cases is an individual set of circumstances. It's a one-off. None of them are connected unless you maybe find somebody who has been involved with multiple of them. They are all standalone, and even in the case of a common defendant, the individual facts about the environment, about the situation, about the confrontation, about the level of danger to the officer or third parties is going to vary in each individual thing. So when politicians go after cops and say that they're all racists or that they're all thugs, what's going to happen is they're going to taint the jury pool. They're going to break down the trust between police and communities. They're going to damage the ability of our civil society to function. No class of people is responsible for all ills. Who is responsible is the wrongdoer. When somebody acts improperly, they should be held accountable. But that ought to occur after a thorough investigation, knowing what the truth is, and finding all of the facts. And with all respect to my elected colleagues, the day it happens, you don't know what happened. Your best service to the community is to calm the waters, not roil them up.
The next question is from Mark Gillespie with the Associated Press.
Yeah, hi. Mr. Pearson, could you confirm on what part of the body Arthur Keith was shot? There were reports he was shot in the back. Are you saying he was shot in the chest?
There was one gunshot to Mr. Keith. It had an entrance wound and an exit wound. So it went through the back near the armpit area, upper back near the armpit area, and out the right side of the chest.
Okay, thank you.
With respect to the gunshot wound and the injury that caused the death of Mr. Keith, the path of travel was front to back. The testimony, the investigation revealed that individuals said that Mr. Keith had a gun and he pointed it at Officer Griffiths. As you can imagine, someone with a gun in their left hand may turn back and be shot and produce that wound. That wound is consistent with that trajectory, as well as if someone had a gun in their right hand and was pointing it back, that wound would also be consistent with an entrance wound, basically just below the left armpit and exiting out the chest.
So basically, he was shot in the upper back. Is that correct?
Yes, near the armpit area, left flank, I believe it was also referred to.
Next question is from Renu Shamiri. She had some sound issues, so I'm going to read it for you. Are you recommending to the Franklin County Prosecutor's Office to prosecute the officers in the Bryant and the T case based on your investigation?
The practice of the office is that where we are the investigators, we do not make legal recommendations to the prosecuting attorney. They are responsible for making those determinations. And so in this case, as in all other ones where we only do the investigation, that analysis and decision on any possible charges is made by the prosecuting attorney.
This is an important topic, so we want to make sure people got it right. We have a couple follow-up questions. The next question is from Matthew Richmond.
Do you have information on how far Arthur Keith was from the officer when he pointed the gun at him, and then how far away he was when he was shot?
Yes. There's various forms of evidence that the investigators use to determine that location of shell casings, which are not completely accurate, but give a range. And additionally, the eyewitness testimony of individuals, civilian witnesses, and officers indicated that he was about, I believe, about 20 feet away from Mr. Keith when Officer Griffiths discharged his weapon. And then he ran, I do not know the approximate distance, but he ran a couple of steps and fell and died.
So but you said that Keith had initially pointed his gun at the officer that led him to shoot him. How far away was Keith when he did that?
It's my understanding it was about 15 to 20 feet away from Officer Griffiths.
Okay.
And the last question of the day is a follow-up from Scott Knoll with News 5 in Cleveland.
Were there any witnesses other than the officer who fired who specifically said they saw Arthur Keith with a gun?
Officer Griffiths did state that in his interview that he saw Arthur Keith with a gun. I don't believe there are any other witnesses who indicated that they saw Arthur Keith with a gun in the investigation. However, his DNA was on the weapon and it was found by him immediately after he was shot and fell. There were commands given that other individuals heard when this incident developed, where Officer Griffiths was yelling at Arthur Keith to don't get out of the van and drop the gun.
Okay, we do have an additional question from Peggy Gallick with Fox 8 News.
Yes, thank you very much. I was just asking if Keith's gun was loaded. Do you know that?
Yes, I do. It was loaded.
Thank you very much.
Hi, this is Mark Gillespie again from the AP. Just to clarify, there were other cameras, but they weren't working?
Correct.
You know how many non-functioning cameras there were?
No, I do not know. I do not know. But the cameras that would have caught more of the incident were not operable and did not record the incident that happened.
Thank you, everyone. We are going to send a press release that will have additional details in the Arthur Keith incident as well. So thank you for coming. If you need additional information, please